You guys excited, right? Okay, bounty hunting is a very interesting and unique field of work. Being that that's what bounty hunting is, it's not regulated like many other occupations. And because that's what bounty hunting is, we don't really have all the stats as to how many bounty hunters are actively bounty hunting, and it's a very dynamic field. So oftentimes bail agents bounty hunt, but bail agents differ from bounty hunters in that bail agents in California, for example, can negotiate bail. So bail agents are seen in not the most favorable light by law enforcement because bail agents play both sides of the fence. They bail bad guys out because in the United States of America, people have a right to bail, and they also are presumed innocent until proven guilty, right? So folks have a right to bail, and then if they skip bail, bail agents or bounty hunters or private investigators then chase the bad guy and remand them back into the custody of the courts. 1997 statistics, as published by Slate, say that about 40% of criminal defendants are released on bail. 88% of bail jumpers are captured by bounty hunters. It's bounty hunters tend to be better at capturing fugitives than police are, because police officers don't have all that time to spend on tracking down fugitives unless you're the U.S. Marshals or you have a special unit that's designated for fugitive recovery or fugitive investigations. Bounty hunters recover more fugitives than law enforcement by far, because bail is a big industry, and usually when police officers do catch fugitives or people with warrants, it's during traffic stops. Fugitive investigations, in my experience, with law enforcement is usually something that's a collateral assignment in most cases. Some departments, like California's Department of Corrections, do have their own fugitive investigators that work with the U.S. Marshals and other law enforcement agencies, but bounty hunters remand more fugitives back into the custody of the courts than street cops. That's for sure. There are 300 full-time and 1,700 part-time bounty hunters in the U.S. Only 2% of skips remain at large. Cops only return 10% of bail skips. Again, these are 97 statistics, so I'm sure as bounty hunting has become more popularized over the years, especially with reality TV shows, where we see bounty hunters showing their line of work to the world and publicizing that. I'm sure those numbers have grown. Most bounty hunters are part-time. Very many of them are law enforcement or retired law enforcement. Very many folks that are private investigators or bail agents, bounty hunt. If you have your own bail company and you're a bail agent, chances are, you're gonna want to have your own in-house bounty hunters, right? And if you could do it yourself, why not save that money? So many bail agents do, in fact, bounty hunt as well. So that's what makes it one of those kinds of lines of work where this has to be something you really want to do if you want to do it full time. And you can. And if you really want to do this full time and you understand the industry and you want to go for it and become Mr. Bounty Hunter or Mrs. Bounty Hunter, have at it. You can do it. You just have to learn the industry and understand the different kind of specs and nuances as to the law and contractual agreements, what you can and can't do as a bounty hunter, and so forth. Bounty hunters are not required to read fugitives their Miranda rights because bounty hunters are not cops. They're not law enforcement. Okay, so bounty hunters don't have to read a fugitive their Miranda rights because they have bond paperwork, which is a contractual agreement, and we'll get to that shortly. But it's a contractual agreement between the defendant, who's now a fugitive because they skipped bail, the bail company, and the courts. And a violation of that contract basically means that the defendant, once they violate that contract and don't show up to court, they agreed to go back to jail. So that's why you don't have to read them their Miranda rights. Evidence illegally obtained by bounty hunters can be introduced into court. That's another thing. In the process of recovering fugitives, there are things you may find that are incidental to your arrest of a fugitive. So when you capture your fugitive and you pat him down, for example, you may find paraphernalia or illegal firearms or weapons, etc. And because you're making a citizen's arrest, you can actually refer additional charges to law enforcement to charge your fugitive with. That's entirely up to them. Your job is solely to remand them back to the courts, so the bail company that hires you as a bounty hunter doesn't have to pay the full fee to the courts for the fugitive in case they don't show up. So you bringing a fugitive back into the custody of the courts exonerates the bail. We'll get to that in just a moment. But anything you find in the process as a bounty hunter, you can refer that to law enforcement. Bounty hunters tend to not want to do that because of liability reasons. Anybody can sue anybody in civil court. So bounty hunters try to just do the job that they're hired to do, and that's capture the fugitive, bring him back on the warrant. But you can definitely, as a citizen, make a citizen's arrest for other things as well. So once you have your fugitive in custody, you can actually refer certain things or crimes you believe to have been committed to law enforcement if that's what you wish to do. And then it's entirely up to the district attorney's office if they want to pursue those charges. Bounty hunting, continuing. So English common law. Bail originates from English common law, although was generally reserved for the upper class and at the discretion of the ruling class. Bail. What is bail? Bail is when a defendant is arrested and booked into jail. Under the 8th Amendment of the U.S. Constitution, he or she has a right to reasonable bail. Bail is a monetary fee determined by either a bail schedule or the courts, a judge, for example, or a magistrate, which must be paid in full in order for a defendant to be released from jail. There are different types of bail. So, without getting into the different types of bail, plainly speaking, in California, there's something known as a bail schedule, which is like a reference guide. There's certain categories or criteria of crime that have a price tag attached to that crime as bail in order for a defendant to be bailed out before they even go and see a judge, right? So folks that can pay that full sum to the courts can bail out of jail. They're promising to appear in court. If they can pay that full amount, they can get out of jail and then appear for their court date, whenever that court date is. Thing is this, bail is presumptive for most, but is restricted by some statutory offenses, so not all defendants qualify for bail. And a bail schedule will vary by jurisdiction. So in some cases, due to the nature of the severity of a crime or an offense, persons arrested or the defendant may have to wait to see a judge, and then the judge will determine on a case-by-case basis. It's at the discretion of a judge whether there is bail, and if there is, what would be a reasonable amount. Regardless, most people cannot pay a full bail amount, so they have to go through a bail company. When you can't pay your bail in full, you go through a bail company, and California is a 10% state. Most of the time, in most states, that's what it is. 10% of your full bail amount is what you need to pay to a bail company in order for a bail company to vouch for you as a defendant to the courts, promising that you're going to show up to court, and if you don't, then the bail company has to pay the full bail amount to the courts if they don't remand you back into the custody of the courts within a specified time frame, which is generally 6 months. So that's how bail companies make their money, is that 10%. So if a defendant bails out of jail, doesn't have the full amount to pay to the courts, but has that 10% of the full amount to pay out to a bail company, the bail company will bail them out of jail and enter into a bond or an agreement. It's a contractual agreement between the defendant, the bail company, and the courts, and also in most cases a insurance company, because the release of a defendant is secured by a deposit and a bond, right? So a bail company will put up that 10% as well as a bond, or either or. It just depends on the jurisdiction. It also depends on what state you're in. But generally, that's how it works. So a bond secures the release of a defendant. So if that defendant does not show up to court, they violated a contractual agreement between the bail company and the courts. The bond issued by an insurance company goes to the courts, but now the bail company has to pay the insurance company, right? It's like a line of credit. It's almost the same concept. So with that being said, it's a very interesting industry, okay? And again, it's contractual, so it's a violation of contract that the defendant is guilty of. They breached the contract with the bail bondsman or the bail company. Not showing up to court, a warrant is entered into the criminal justice system for the defendant's arrest, and a bail company then has a certain specified time frame to recover that fugitive. And that is where bail agents to whom a defendant is obliged to get their jurisdiction, because that defendant, when they're released out of jail, when the bail company vouches for him, unless you're released at your own recognizance, usually when you bail out, you're released into the custody of a bail company, essentially. That's your probation officer if you're a defendant. So commercial bail is legal in most states except for Illinois, Oregon, Kentucky, Massachusetts, and Wisconsin. Okay? We'll get to that as well, because there is a case law that legitimizes bounty hunting, but there is no actual federal statutory authority regulating bounty hunting. So it's really up to the states to come up with their own laws and regulations, and we'll talk about that as well. A bond is a contractual agreement between the defendant, bail company, and the courts, commonly secured by an insurance bond when the full bail amount cannot be met. Bounty hunting is legal in 46 states, including California. And you would think, with all the restrictions that we have in California as to firearms, all the licensing requirements that exist, California would be more restrictive on bounty hunting, but they're not. In California, bounty hunting is not licensed. There is no licensing requirements, although there are training and other requirements which must be met in order for a private person to engage in bounty hunting. So for some reason, the Department of Consumer Affairs and the Bureau of Security and Investigative Services, which licenses private investigators and security officers, decided they don't want to license bounty hunting, just due to the nature of bounty hunting. And this is something that's been questioned over and over by legislators and the ACLU and the media. You know, should bounty hunting be legal? And there's a story behind that of bounty hunting gone wrong, and we'll talk about that. Bounty hunting is illegal in 4 states, which are Oregon, Kentucky, Wisconsin, and Illinois. A bounty hunter, bail agent, or private investigator engaged in bounty hunting is a representative of the bail company to whom the fugitive is obliged. So we talked about that already. That when a defendant gets out of jail, they're released into the custody of the bail company, bailing them out in case they can't make the full bail amount, right? In which case, if they were able to make their bail in full, they wouldn't be obliged to anybody other than the courts, of course. Bounty hunting continued. A bounty hunter's authority. Taylor versus Taintor is a Supreme Case ruling granting bail persons sweeping jurisdiction over a defendant who is contractually obliged to the persons responsible for the defendant's bail. All right. Taylor versus Taintor although a Supreme case ruling, it's not binding. It's what's known as persuasive. So ultimately, it's nothing more than a reference guide for bounty hunting. It doesn't have any statutory authority. There is no federal statute that governs bounty hunting. If there was, I would be okay with that, because we at least would have an industry standard. So long it was not heavily restrictive. But Taylor versus Taintor is a reference guide. So the way the Constitution and the law works is there's something known as a supremacy clause in respect to the supreme law of the land, which is the Constitution. The supremacy clause is basically that all other laws, federal or state, have to be in accordance with the supremacy clause, with the supreme law of the land, and with any U.S. treaties. So this has also been upheld by Supreme case ruling known as Marbury versus Madison, 1803. Any law repugnant to the U.S. Constitution is null and void. Constitutionally, the states have a right to make their own laws, right? Every state is its own sovereign state, so every state has a right to make its own laws, so long as those laws don't conflict with the federal law or the supreme law of the land. Same goes for federal laws. They must be in accordance with the supreme law of the land. They must be constitutional. All right, so because that seems to be the case, there are some states that have outlawed bounty hunting. I would find that questionable, but until somebody actually goes and tries to set a precedent case with that, that's the law. So if you plan on bounty hunting in states where it's illegal, Taylor versus Taintor is not going to cover you. It's not going to protect you. Just move to a state where you can bounty hunt, like California or Nevada. Because the law is the law, but every state has its own views on how to interpret the Constitution. And because every state has the right to make its own laws, and there is no federal law for bounty hunting saying that bounty hunting is legal, some states have decided to outright fully ban bounty hunting, which is unfortunate, but hey, you got 46 states where bounty hunting is legal, so choose one, right? California Penal Code 1299 sets the rules and guidelines for bounty hunting and was made state law under the Fugitive Persons Recovery Act. And that is the statutory authority which governs bounty hunting in the state of California. So bounty hunters are not law enforcement or peace officers. PC 1299 does not give you any kind of arrest powers that a citizen does not have. You don't have qualified immunity, which is something that law enforcement and peace officers have, because they're sworn peace officers. They have certain standardized training, and they are given certain discretionary powers. Bounty hunters don't have any discretionary powers, thus you don't have qualified immunity. So if you're a bounty hunter, or that's something that you wish to do is bounty hunt and go after fugitives as a civilian, just know that you have to be very precise and you can't miscalculate your actions when bounty hunting, because bounty hunters have gone to jail by breaking the law when bounty hunting. You don't have any qualified immunity. If you have a badge, that doesn't mean anything. Anybody can buy a badge, right? That's not gonna give you any kind of protection. So that's why bounty hunting is so risky, it's so dangerous, and there's so much liability involved. Even if you do it the right way, even if you're very well trained, okay, even if nobody gets hurt in the process of you bounty hunting, there's a number of things that can go wrong. And if you don't get criminally charged, expect to be sued civilly. That's very possible. So you want to definitely be on your best behavior, as everyone should. Okay, let's talk about the term officer of the court. This is really interesting because, again, bounty hunters have gone to jail for impersonating peace officers by stating that they're an officer of the court, which is a very generic term. Okay, it's a generic term that's used in common law jurisdictions, and it's applied to all those who in some degree in the function of their professional or similar qualifications have a part in the legal system. So an officer of the court could be a jury member, it could be an attorney, it could be a prosecutor, bail agent, bail company, or their representatives. Anybody and everybody involved in the judicial process becomes an officer of the court. That's a generic term. Don't use that term. Refrain from that term. Don't identify yourself as an officer of the court to anybody. Okay, even if you're an officer of the court because you're a bounty hunter remanding a fugitive back into the custody of the courts, you have an interest in that person because you're the bounty hunter that's a representative of the bail company that hired you, to whom the fugitive is obliged. Refrain from using officer of the court because you can go to jail for impersonating a peace officer. All right? Bounty hunters are private citizens. Repeat that with me. Bounty hunters are private citizens. Bounty hunters are private citizens. Bounty hunters are not peace officers or law enforcement officers. Okay? Some law enforcement officers or peace officers, whether they're retired or active, do bounty hunt as a side gig, right, for extra money. Some folks do that as a business. People that are law enforcement that do that as a full-time business as well. That doesn't mean that bounty hunters are law enforcement or peace officers. Okay, so just don't confuse the two.